Good morning. I just finished making our first videotape and I didn't even have the movie camera running. So I'm going to do this over again. Bad for me, good for you. Maybe I'll do this one better. At any rate, good morning. Nice to see you. Yesterday I finished on a slide from the Basics Part 1 that was about law of equity. And I wanted to go back over this just one more time because this is really, really important. You're going to hear me say this or ask you, what are the two worst words to a journalist? The two worst words to a journalist or a publication are prior restraint. Prior restraint. That's a bad concept. I mean, it has its place, but we don't like to do that. And our founding fathers let us know in the Constitution that this was to be avoided at all costs. You do not want to keep somebody from talking. And that's what a prior restraint or an injunction, as it's sometimes called, is. It keeps you quiet, or it keeps a newspaper from printing something because the judge thinks that if they do, there will be some harm to somebody. And so we're trying to nip it in the bud, as Barney Fife used to say. We're going to nip it in the bud before we get there. So we have to deal with prior restraint. It's a supplement to common law. This is when the judge issues a restraining order or an injunction to prevent the prospective perpetrator from acting before harm occurs. Now, sometimes some harm has already occurred. I'm going to give you an instance of that. There once was this, I'm not telling a joke, this is a real thing that happened. A man working for Apple computers in the design department was carrying around a prototype of the newest, the latest, the greatest iPhone. It was significantly different. Nobody had seen it before. They were reviewing it. They were using it. They were trying to see, what was good about it, what wasn't good about it. And he had it in his pocket, and he went to lunch one day, left the Apple office and went to lunch. Sat at the bar, ate his lunch, left. And a couple of hours later, he realizes he doesn't have the prototype with him. He doesn't have the phone. Oh my gosh, where did I leave it? Then somebody brings it to his attention that there are photos of this new prototype on the internet. Wow, he freaks out. He tells his bosses, and immediately they get their attorneys on it, and they file a suit against this person, and they need to get prior restraint. Yes, he's already created some damage, but we can keep him from harming the Apple company anymore. With those special photos out there on the internet, Apple's competitors can see what this new design is. They could steal it. This would cause a lot of harm to Apple. So the judge issued an injunction against this man, against the man who was posting the photos, made him take the photos down. I don't think anybody got into super bad trouble, but I think you can see that when something is about to cause damage or more damage, the judge comes out and says, okay, stop this. You cannot spread this information. It's proprietary. It's owned by Apple. You can't pass this around. It's secret. So that is where the law of equity comes in. It's a law that makes you stop spreading information that can cause harm. So now we go to the part 2, the basics part 2, and this seems to be difficult for my students to remember, but because they get it confused with other things, but I want to be very clear. Our law has two systems. One is the federal system, meaning national, federal, and one is the state system. We have state laws, we have federal laws. These are the two systems of law that we have, federal and state. I don't know if you want to write that on your forehead. No, don't do that. Your hand maybe, and walk around a few days and remind yourself, because it's really important that you get this straight. There are 3 conditions necessary before you can bring a case to court. If you've already hired an attorney, the attorney will make sure that these things are taken care of, but you need to know what they are. You might think twice about going to an attorney. At any rate, the judge will look at these things and decide whether he even wants to allow you to come into court and sue. So number 1, it must be a legitimate controversy ripe for review, meaning it can't be something that court already considered just a few months ago or 6 months ago or maybe even a year. It's got to be something that's fairly new and hasn't been adjudicated yet. So that's number 1. Number 2, the parties in the case must have standing. And I don't mean you must be standing on your 2 feet as opposed to sitting in a chair. Standing is what qualifies you to even bring the suit. As they say in Alabama, if you have a dog in the fight, it's likely that you can bring the suit. If you don't have a dog in the fight, you are not, you don't have standing. If this has nothing to do with you, you don't have standing to even bring this case. And number 3 is that the case or issue must fall within the court's jurisdiction or sphere of influence. Now, let me give you some examples. There are 2 things noted here. Jurisdiction, which is the area that you're in, and sphere of influence is the subject matter that is handled by that court. Jurisdiction, if I'm in Alabama, I can't go to Colorado and go into a court and plead a case. Why would I go to Colorado? That's not my jurisdiction. My jurisdiction is in Alabama. The sphere of influence or subject matter means that if I'm filing a bankruptcy suit, I'm not going to go to family court. I'm not going to go to divorce court because those have nothing to do with bankruptcy. So bankruptcy cases have to go to bankruptcy court. So that's pretty simple to understand. So those are the 3 conditions. Now, if you're following me in the PowerPoint, slide 3 has an illustration of how the federal and state systems are separated. I'll go over this and then I'll start a new video. The state system starts in the state trial court, and every state has several or many. Of course, they're divided by subject matter or sphere of influence, as I said before. So you would enter your state suit in a state trial court. If you didn't like the decision there, you can appeal that decision, but you need to go to a new court, which would be an intermediate appellate court. There are 39 of 50 states have such a court. Just remember, you don't have to remember 39 out of 50. Remember that that's the next place you go if you didn't like the decision. If you did like the decision, but your opponent obviously doesn't like the decision, your opponent can appeal this decision by going to the intermediate appellate court. You have one more place to go in the state if you don't like the decision, and that is the state Supreme Court. We've had a lot of interesting things happen with our state Supreme Court and the Supreme Court justice over the years. I hesitate to go into that right now, but our Chief Justice has been in and he's been out, and he's been in and he's been out for doing certain things that were not by the rules. So anyway, we have 3 major places to go in Alabama. Now, if we don't like what happened at the state Supreme Court, we have a court of last resort. That is the most famous court in the United States, and it is the Supreme Court of the United States. Supreme because that's it, folks. You get a decision there, that's the end. Now, if this Supreme Court does not want to entertain discussion about your case, they can refuse to hear your case. They have that option. They can refuse, or they can accept it. But if they accept your case, you must abide by that decision. There's no other place to go to appeal. That's the final decision. Now, if you have a federal case, and your attorney can tell you which case you have, you would enter it through, like on Law and Order, through the U.S. District Court. That is a federal court, and there are 94 of these around the United States. So we don't even have 2 per state, or else we would have 100. We have 94. Now, if you don't like the decision there, you have an appellate court you can go to, which is the U.S. Courts of Appeal. You can appeal that, and then once again, the only place you can go after that is the Supreme Court. So I urge you to look at this drawing and get to understand our court systems.